May I please, Your Honor? I would like to mention item number 3. The counsel for the petitioner, Mr. P. Obin, is out of station.
No objection, ma'am.
One prayer made by the appellant. This is matter after 2 weeks.
Your Honor, similar prayer for item number 8 and 14. Heard for the petitioner.
Lordship, I'm praying for item 14, Lordship.
The 14 more. On prayer made by the petitioner. This is matter after 3 weeks.
Obliged.
8 we'll leave it as it is because it's in connected
Yes.
with others.
Okay.
So we'll see how it goes.
Okay.
Lordship.
Obliged, Your Honor.
May I please, Your Lordship, I beg to mention item number 11, Lordship. Lordship, I pray for some more time, Lordship, because we are newly engaged counsel. Earlier, Ma'am Anjali Sheila was the counsel, now she is a GA. So we send this vakalatnama to the client to get his signature. So kindly give.
Then the counsel has submitted that he has been recently engaged by the petitioner and the power could not be filed today. It is prayed that some more time may be allowed as far as this matter is concerned. On premier, the same is allowed. This is matter of 3 weeks.
Highly obliged, Lordship.
Lordship, I like to beg item number 13. My senior respondent, she is not well. Kindly allow us some more. Item number 13.
You are for?
Respondent,
Respondent what?
EPF.
Okay.
Objection.
EPF.
Yes.
Accommodation has been sought on behalf of the conducting counsel for the respondent who is said to be indisposed for the day. On no objection by the petitioner, the same is allowed. This is matter after 2 weeks.
May it please your lordship. Lordship, I beg to mention item number 15. Learned senior counsel is out of station. Subject to your lordship's convenience.
You are for petitioner.
Yes. Yes, my lord.
For the respondent, Your Lordship. No objections.
On prayer made by the petitioner, not objected to by respondent. This is matter after 3 weeks.
Obliged, my lord.
Please, Lordship. Lordship, I beg to make mention for item 9, Your Lordship.
Mine is a very long pending matter.
Lordship, we pray for 2 weeks' time, Lordship, in this matter.
What is this matter about?
It's about the payments of salary of the Lordship.
And we are disputing it, saying that
per
with the
last-
same name, two schools
Oh,
are
that
there.
thing. This matter was heard or?
Hard at length, and ultimately we could not come to any conclusion. The issue about that salary was there.
Lordship, as per last order, is it that
Was it that
supposed to
the
take
salary was
instructions?
misappropriated by the secretary?
Yes, some last remaining, she was requested to take her portion of the salary, which she declined. And thereafter she was no longer in the school and she was long absent from her job. So question of her salary was not at all there.
But who is to pay the salary?
Is the managing committee.
Managing committee. You are managing committee.
The previous secretary,
No, see, secretary may have expired. There could have been an allegation against him of misappropriation. But for that, the petitioner should not suffer.
present.
No, whatever the case may be, you are the present. See, like they say, people come and people go, but the entity remains. You are there now in the helms of affair. If something can be, see, this is a matter of 2014. The petitioner, rightly or wrongly, has suffered going through the process, the court process for that matter, from time to time, year to year. And at the end of the day, how much will she receive, if at all she is to get? That will be a pittance compared to what has been, what she has gone through. You try to work out. See, the best solution would be, instead of going to all these legal hassles, try to work out. Find out if there's something that could reach out to the petitioner, talk to her, and then try to work out. I'll put this off for 3 weeks and try to do that on pre-made by the parties, on the assurance that efforts will be made to settle the matter outside court. Matter is adjourned. List the same after 3 weeks.
Lordship, a similar prayer for item 16, Your Lordship.
You're for?
I'm for petitioner, Your Lordship.
Who's for the respondent?
Mr. Pachataji, Your Lordship, is firstly.
16, huh?
16.
Yes, Mr. Mansuri, you are there.
I'm for the private respondents.
Any objection?
How long?
Lordship, 2 weeks, Lordship.
What is it matter about?
It's about 42, Lordship. Quashing, Lordship.
What exactly is the cause?
This petitioner here in my lord and the private respondent, they are brothers by blood.
Okay. But why? I think there was some overtures, made by the court.
I had showed,
to try
I had expressed my desire that I'm willing to settle, but nobody has come from their end.
If it can be worked out, you try to settle. Try to. Since there are cases which are proper for mediation to take place. Mediation may be official or otherwise, but in mediation, the outcome would be, like we used to say, a win-win situation. Especially, where parties are very closely related, like brothers or siblings or spouses, etc. You try to work out and see on pre-made by the parties. To try and forge a settlement outside court. Matters adjourned. This is after 3 weeks.
Supplementary cost list, item number 1.
Yeah, please, Lordship. Lordship, I'm praying if this matter can come up on Monday, Lordship. The arguing counsel is having personal difficulties.
What is the matter about?
This is basically, my lord, this is a quashing petition, and the issue involved herein, my lord, it's a civil dispute, Lordship. It's pertaining certain property, Lordship.
Mr. Panthi, if you, I think they are all private respondents.
Yes,
private respondent. Then you take steps for issue of notice.
Will do it.
And then let the matter come up after whatever 2 weeks or so. What is there? I don't. Why should if it is an ongoing proceeding?
Yes, Lordship.
The court will not stay the proceedings.
But Lordship, here the issue, if my lord may examine, kindly, my lord, may kindly have it on Monday, Lordship. The arguing counsel, he's having difficulties, Lordship.
On pre-made by the counsel for the petitioner, this is matter on Monday.
Obliged.
Legal cost list, item number 1.
Yes, yes.
This is a revision petition against an order passed under section 82 of the CPC, whereby the Honorable Court has been pleased to grant waiver to the plaintiff from issuing a notice under section 80, which in our respectful submission would be the mandatory requirement prior to the institution of the suit. Lordships will come straight away to page 25, which is the impugned order.
Yes.
From pages 26 till page 31, the court records the assertions of the parties. And 32 is where the court has given its reasoning as to why it considers it an appropriate case for granting waiver of issuance of notice. And Lordship will find that at page 32 in the second last paragraph.
Yes.
After hearing the learned counsels, without going into merits of the instant suit, and in view of the discussion above, the court is of the opinion that there are materials that reflect urgency for this court to waive notice as required under subsection 1 of section 80 of the Code of Civil Procedure 1908. Now, in one paragraph, the court has concluded that there exists an urgency which warrants dispensing the requirement of notice. Lordship, at the outset, I would like to draw your Lordship's attention to section 82 of the CPC. The requirement therein is that the court must assess from the plaintiff whether there are adequate grounds which disclose an urgency that if a notice of 60 days is in fact issued to the government, then the subject matter of the suit itself may not survive, or the suit may be rendered infructuous,
Yes.
or grave and irreparable harm may occasion to the plaintiff. Straight away, Lordship will find section 82.
Yes.
Proviso. Provided that the court shall, if it is satisfied,
Yes.
after hearing the parties, that no urgent or immediate relief need to be granted in the suit, return the plaint for presentation to it after complying with the requirements of subsection 1. Therefore, if in the assessment of the court, it concludes that there is no requirement of any urgent or immediate relief, then it is bound to in fact return the plaint with a direction for compliance with the notice requirement under section 81. Now, in this backdrop, Lordship, I would like to draw Lordship's attention to what is the prayer made in the suit, and whether at all that was urgent or immediate relief that was being sought by the plaintiff, which, if not granted immediately, would be rendered infructuous. Lordship will find the prayer at page 62. The plaint starts at page 34 and the prayer is at 62.
Yes.
Now, Lordships, so far as I am representing the government, therefore I am not concerned with prayers 1, 2, 3, 4 and 5. The prayer that is relevant so far as I am concerned is prayer number 6, which Lordship finds at page 64.
Yes.
Which is grant a permanent injunction against the defendant government authorities, restraining them from processing any applications filed by Shri Telampade or any individual acting through him praying for mining lease or the like over the suit premises. Now, essentially, Lordship, just by way of background, what the dispute is that the plaintiff and the private defendant both claim to be leaseholders of a land which they have leased from the Hashak clan. Am I audible to my lord?
Yes, you're audible, but anyway, there are some glitches though. Doesn't matter. Go ahead, please.
Lordship. So they claim to be leaseholders, and in the capacity of leaseholders, both the plaintiff and the private defendant have applied for certain mining permissions on the leasehold land. Now, the dispute that the plaintiff has brought to court is that there is purportedly some overlap between the land which is leased to the plaintiff and the land which is leased to the private defendant. Now, in that context, the plaintiff seeks to urge before the trial court that there must be no further consideration of the lease applications which have been filed by the private defendant over his parcel of land, which is why, if Lordship finds, prayer number 5. Prayer number 5 is grant a permanent injunction against Sri Telankade or anyone acting through him, restraining them from filing any applications with regard to grant of permissions of mining lease or the like in the suit premises. So the grievance of the plaintiff is that the private defendant must not be allowed to pursue any mining applications in respect of his portion of the land, since there seems to be some overlap over the over the leasehold premises. Now, in that context, prayer number 6 is sought, where a blanket injunction is sought against the government authorities that the government authorities must not process any mining application made by the private defendant.
With regard to the land, the land in suit.
With regard to the land, the subject land.
Yes.
Now, if Lordship sees prayer number 6 as it is worded, at the outset it appears that the requirement is a permanent injunction against the government authorities. Now, this relief, if at all can be granted to the plaintiff, can be only granted by way of a final relief. It can never be an interim relief, since the grant of an injunction to process the mining applications at this stage would be amounting to virtually decreeing the prayer number 6. So therefore, there is no question of such a prayer in fact being granted by way of an interim relief or an urgent relief. The trial court would necessarily have to invite the parties to undergo trial on these aspects, establish their respective cases, and then, if the facts so warrant, a decree may be passed in favor of the plaintiff or refused, whether or not a permanent injunction can be granted in this. Under no circumstance can there be an urgent or immediate relief granting prayer number 6. It is in this context that the prayer for waiver of section 82 was required to be assessed by the Honorable Court, which in my respectful submission has been erroneously misconstrued, for the reason that the court could have never come to a conclusion that an urgent or immediate relief in the nature of a permanent injunction or even an injunction could be granted against processing of mining applications. For the simple reason, Lordship, that these are reversible processes. If the court were to find at the end of the trial that the land of the private defendant was not fit to be put to use for a mining application, then the entire process that has been undertaken by the government authorities on that land would stand invalidated automatically. But presently, at this stage, where trial has not commenced, where the issues have not been framed, where the parties have not established any prima facie case or balance of convenience, then at this stage, for the court to have considered that there is an urgent or immediate relief in the nature of relief prayed at prayer number 6, which warrants waiver of issuance of notice under section 80, in my respectful submission, Lordship, that course of action could not have been taken. Now, Lordship will just find at page 209, certain authorities that were placed by the government before the learned trial court to establish the fact that the section 80 notice was 209, page 209.
Yes. Yes.
Before that, if Lordship, I apologize, if Lordship could see page 167, the grounds on which the waiver is sought. (167) is the application under section 82.
Yes. 167.
Now, Lordship will find yes, at page 172, paragraph 7. This is the sole paragraph on the basis of which waiver is sought.
Yes.
That failure to grant immediate relief by waiving of the requirement of section 80 CPC would result in irreparable harm to the applicant's legal rights due to the arbitrary and wrongful actions of the government authorities, first in registering the impugned lease deed and further in processing the mining lease application of Shri Telangpade. There shall be irreparable harm, loss and injury to the plaintiff, and if this application is not allowed, Shri Telangpade or anyone acting through and or under him shall enter into the suit premises and start mining activities in the suit premises leased out to the applicant, for which purpose the lease deed dated 19th August 2014 was executed in the first place, thereby causing depletion in the natural resources and causing irreparable loss and injury to the applicant and also to his legal rights. Now, Lordship, I'll just pause here for a moment. The assertion of the applicant in this case is due to the arbitrary and wrongful actions of the government authorities in registering the lease and processing the application. Now, these two facts are yet to be proven in the course of trial. At an interim stage, if an application for mining lease is being processed, the presumption would be that it is being validly processed till the time by way of detailed trial and evidence it is established to the contrary. The court could not have presumed that the processing of mining applications is arbitrary or illegal at this stage. It has to proceed because these are statutory processes under the MMDR Act. Lordship knows that the full court is also cognizant of the fact that coal mining applications for lawful mining in the state are in fact at advanced stages of being processed. So therefore, these processes are ongoing. Now the question therefore is whether this could have been stayed. Presently there is no stay, but whether the plaintiff should have been permitted to proceed with the suit without issuance of a notice. Whether there is sufficient urgency in the matter that warrants dispensing of the notice requirement. Now Lordship will further see, in other words, if this instant application is not allowed and the applicant is directed to issue notice under section 80 CPC to the government authorities, the very protection granted by the Honorable High Court of Meghalaya in form of status quo for a period of 3 weeks from the date of passing of the order of 18th May 2023 would be futile, and the government authorities will proceed ahead with granting mining permission to Sri Telangpade in the suit premises pending the disposal of the issue at hand. Now, there is one additional fact which I have not placed before my lords, is that first the plaintiff approached this honorable court by way of a writ petition. That writ petition was disposed of by the order dated 18th May 23, finding it to be not maintainable. But the writ court was pleased to grant status quo for a period of 3 weeks so that the plaintiff may obtain whatever relief he has in accordance with law. That 3-week period has long since ended, and therefore there is presently no status quo. The mining applications are being processed. So the question therefore was that whether there existed any immediate or urgent relief that warranted dispensation of the notice requirement. And only paragraph 7 is the only paragraph wherein the case has been set up for granting of waiver. Now, against this lordship, at page 209 is our response.
Yes.
Paragraph 7, lordship.
Paragraph.
At page 219.
Yes.
It is humbly submitted that the Honorable Supreme Court, on the issue of rejection of plaint for non-compliance with Section 80 of the CPC, in the case of State of Kerala versus Sudhir Kumar Sharma, has held as under. It is an admitted fact that no order has been passed on an application filed under Section 82 CPC. Till a final order is
Sorry. I can't hear you.
Sorry. Lordship. If ultimately the application is rejected, the plaint is to be returned, and in that event, the application filed on behalf of the appellants under 711 is to be granted. Lordship, several judgments were quoted by us. I need not detain the court by reading the judgments again. This singular point that these judgments establish is that the requirement of issuance of notice under Section 80 is mandatory in nature. Number one. Number two, these judgments also establish that the grant of waiver cannot be done in a mechanical manner. A suit which is filed without issuance of notice under Section 80 would be presumed to be defective. And that defect cannot be regularized simply by way of an application under 82. Because if Lordship finds under Section 80, the requirement is of a notice of 60 days. So the court must only assess whether giving this notice for a period of 60 days would frustrate the suit. It is a very, that would be the basic test that would be applied under Section 80. That if by giving the notice under Section 80, the suit itself is frustrated, then the court shall grant waiver. But if by giving the notice, the suit is not frustrated, then the court shall not regularize this defect by granting waiver under 82. Now the test therefore in the present case is that whether if the plaintiff is asked to give a notice under Section 80 for 60 days, whether his suit would be frustrated or not. And the answer to that is clearly no. Because ultimately if the suit succeeds, then all the permissions granted, if at all granted, to the private defendant. Because today the mining lease is under process. There is no guarantee that the lease will necessarily be granted in favor of Mr. Telangpade or not.
See, Mr.
That
Sai,
is subject.
Mr. Sai, what about the fact that in the meantime, what happens if the resources are being, mined? They are being, as has been asserted, the resources are depleted.
Yes.
That would
Lordship, even if-
amount to an irreparable loss.
No, Lordship, because that could also be adequately compensated
It can
in money
be
terms.
by way of money, perhaps, but the resources per se would be lost.
The resources, Lordship, whether the mining lease is granted in favor of the plaintiff or granted in favor of the private defendant, the resources will necessarily be depleted by way of mining.
Exactly.
So
But it would be see, the plaintiff vis-a-vis the defendant, private defendant, not as far as the government is
Correct.
concerned.
Not so far as the government is concerned. So far as the government is concerned, both persons, whoever gets the lease, will be entitled to mine it, and therefore there will be depletion of resources. But in a lawful scientific.
But it also depends on where the arrow of advantage is pointed out by the government.
Lordship, that may not be the appropriate parameter at this stage, for the reason that the application which is being processed has not yet been granted. It may so happen for any number of defects, the application may not in fact be processed.
So, Mr. Sai,
Today we are.
So, Mr. Sai, let's put
Yes.
it this way: if the government can assure that no mining licenses or permission is given out at this point of time, then the suit can proceed. The notice as required under Section 80 will be issued upon you.
Lordship, but then that would in essence be equal to granting prayer number 6 in the plaint by way of final relief. How can a plaintiff get by way of interim relief something that is a final prayer in his suit?
That is an issue in itself, boss.
The plaintiff could never get a interim relief which is identical to the final relief prayed. That's number one. Number two, so far as the irreparable harm that is prayed will occasion to the plaintiff, that is something that is neither here nor there, for the simple reason that the mining by itself is a process that would lead to depletion of natural resources. Now, whether the permission is granted to the plaintiff or to the defendant, there would be depletion of mineral resources. If anything, if it is the case of the plaintiff that the defendant gets the permission wrongfully, then the plaintiff has a claim in money terms against the defendant and can seek adequate compensation, and vice versa. But ultimately, if the mining is operationalized, there will be depletion of natural resources. So that fact by itself, in our respectful submission, Lordship, would not have any bearing on the issue of notice. And the notice we are talking about is for a period of 60 days only. So 60 days is not something, not a period in which the permission will be granted and the entire mining resources in that area would be exhausted or depleted completely. But the requirement of the law is that a 60-day notice be in fact granted so that the government can evaluate for itself whether this is a matter that can be settled without litigation. This is a matter that can be evaluated by the government outside of court. That is the requirement of Section 80. So 60-day period is not a period within which the heavens would fall proverbially. It would be a case where the suit would remain defective, but for the want of notice. And the courts have repeatedly said that you may not regularize a suit by way of an application under 82. If you have not given a notice under 81, then your suit is defective. Your suit will be returned. The suit must not progress. It is not maintainable. It is a ground where the suit should in fact be dismissed, returned under 711. There are high authorities that say so, and Lordship, I have detailed that in my response at page 209. The entire response contains several judgments on that, and I need not defend the court with that. So the only evaluation that my respectful submission that is required is whether 60-day notice could be insisted upon or could not be insisted upon. If it is insisted, whether the plaintiff is non-suited or not. In my respectful understanding, the plaintiff would not be non-suited if a 60-day notice is insisted upon. And therefore, on that count alone, Lordship, the impugned order has committed, there is an error in the impugned order. because the court has not evaluated the time period. The court has not evaluated the provision at all. The court simply says that there is an urgency in the matter. But whether that urgency is within the period of 60 days, whether that is within the period of what is prescribed under 82, these are evaluations which the court has not done. In that sense, the order is also non-speaking because it entirely records the submissions and in one paragraph it says that there is an urgency in the matter. So therefore, in that sense, also this is an order that is eminently fit for seeking revision. Lordship, so these are my broad submissions on the matter. Lordship, I believe that the issue is very short. It is just whether or not the notice should be insisted upon or not. In my respectful understanding, the notice should have been insisted upon, and the suit should not proceed in absence of any such notice.
Yes, who's appearing for the, how many respondents are there? You're for 11 and 12. I don't think you have any rule as of now.
Lordship, in fact, the only role that somebody has is me, because I am the plaintiff in the original suit there.
You're the plaintiff.
I am. Remaining other defendants, they have got no role to play in the matter. That they will be telling, that the revisionist will be telling why has...
In the plaintiff you made a party. If you are not necessary party, then you make a submission that you are not necessary party, you try to submit. In plaint 11 and 12, we are dependent on the 11 and 12. Now to say that you are not necessary party or you are not to be heard.
It's not a question of not being heard. It is a question of looking at the impact of the impugn order.
I stand on the same footing as the petitioners. I am also government. Responding to 11 and 12 are also government. We also are entitled to a section 80 notice. Because we are also dependent number 11 and 12 in the suit.
But the impugn order is also not directed against you.
My lord, it's a better question of impugn order. Law says, my lord, before filing a suit against government, whether it is state government, central government, there is a defined...
That of course. Section 80 is very clear.
Very clear.
We are not...
11 and 12 are also government, my lord. And we could not have filed a suit against us without issuing section 80 notice. One very relevant aspect in the entire matter. I have two-fold submission in this entire matter. Number one, your lordship will examine the entire thing, my lord, only with regard to the requirements of section 80, which says that 60 days notice is required. My lord, so what we have to keep a timeline of 60 days, whether waiting for 60 days would defeat the entire purpose or would defeat or frustrate the suit. Ultimately, what section 80 says that you issue a 60 days notice, response comes from government, doesn't come from government, you are entitled to file a suit. That's the first aspect, my lord. So the examination has to be from that perspective, my lord. Only waiting for 60 days, what will be the impact of that in the relief claims of whether mining the resources will be depleted in 60 days or whether at all the mining operation can be started in 60 days, my lord. That is one aspect, my lord. Second aspect, my lord, what I understand and what will follow, my lord, first a section 80 application is filed before the court, my lord, seeking leave to file a suit. If that is granted, then we file a suit. And along with the suit, then we file an injunction application. Here what has happened, my lord, everything is filed simultaneously.
So you mean to say that even an application under section 80, even an application under section 82 has to be independent?
Yes, my lord. Section 80 subsection 2 says that suit can be filed with the leave of the court. So first leave have to be obtained from the court, my lord. Once leave is granted, and here the leave is granted by the impugn order, my lord, that was passed on 12th June, my lord.
Come again, where's the impugn order? Yes.
12th June leave is granted, my lord.
June.
Page 26 at the top, my lord. 12th June is the order passed leave granted. granting leave to the plaintiff, my lord. And Lordship will see at page 33, my lord.
Yes.
The trial court issues notice on 29th of May. In the suit.
So this presupposes a suit being filed before the application has been was pursued.
So, my lord, in my observation, this is a totally incorrect procedure adopted by the learned trial court, my lord. If at all, they could file a suit only after the leave was granted under section 80 subsection 2 CPC, my lord. Post 12th June, my lord. Here the suit itself has been filed on 27th May. And not only this, my lord, injunction application has also been filed. My lord, in my observation, that is a totally incorrect procedure adopted by the learned trial court. So, my lord, also kindly take into consideration that aspect. First, leave is to obtain, my lord. It is like filing an appeal. Normally, what happens, my lord, if a party is not a party in the, if a person is not a party in the original proceedings, my lord, he is aggrieved by order, he has to file an appeal. So, first he has to obtain the leave from the court, my lord, that though I was not a party, but I am aggrieved by the order passed by, for example, learned single judgment. First, you obtain a leave from the appellate court, my lord. I was not a party, but I am aggrieved. Please grant us a leave to file an appeal. Once the leave is granted, then only I can file an appeal. It is the same here also. And secondly, my lord, as I submitted, my lord, Lordship will kindly examine whether 60 days. It's not a question that we are asking for 1 year or 2 years. Only 60 days. Whether in 60 days permission will be granted, whether they can set up plant and machinery for mining operation, and they can start mining within 60 days. And what is evident is that at this stage only the application is in process. Can't they wait for 60 days?
Yes, what do you have to say?
May I, Lordship? Lordship, facts have been taken up in bits and pieces, and they have been placed before your Lordship. Kindly grant me the liberty to take your Lordship to the genesis of this case. Lordship, I obtained a lease deed over a particular plot of land in the year 2014.
Yes.
Now, accordingly, Lordship, sometime in the year after 2020-21, I had applied certain applications for giving me the pre-permissions for applying for mining lease like forest clearance. Now, Lordship, while I had applied to one of my applications, the first application where I got to know, on the 21st of September 2022, Lordship, the dates would be very important in this. On the 21st of September 2022, the DFO, he writes to me, Lordship, it is at page number, in the revision petition, page number 130.
Yes.
May I, Lordship?
Yes, please.
Lordship, he says, with reference to the above, it is to inform you that this office, while processing your application for forest clearance for the proposed prospecting license on limestone for an area of 40 hectares at Rongdasura, Southwest Khasi Hills, it was found that your proposed area, as per GPS map, overlapped ML Guarantor Nonghalam, Southwest Khasi Hill district, with that of Shri Teilangpede. I regret, Lordship, this is of essence. I regret to inform you that further necessary action could not be taken from this end until the matter is sorted. The same may be intimated to this office as and when done to enable to take needful action. Now, a copy of this letter has been sent, Lordship, at the footnote. Lordship will see it has for information and necessary action. Following this letter, Lordship, page number 132, more specifically at page number 133. I write a letter. What is of essence here, Lordship? Para 5.
Yes.
And para 7. Lordship, I'll first go through para 5. That now, according to the content of your letter mentioned above, it is clearly understood that there is an overlapping of property, but it is not known who has overlapped whose property. There is no clarity, and your office has also clearly mentioned that such applications can only be entertained after the matter has been settled. Hence, I pray that considering there are certain discrepancies with regards to the property, any applications pending or put forth by Shri Tailang Pradesh should also not be processed as the matter of property discrepancy is not settled. Lordship, I write to the DFO that you have stated that there is an overlap in the property, but we do not know whose property has overlapped with whose property. Till now, I am clueless with the second lease deed. So I tell the DFO that since you have told me that you will not process my application, then please do not process the application of Shri Tailang Pede also, since he has also been the one to whom a copy of that letter has gone for information and necessary action. That would mean to abide by the contents of whatever is written in the letter. Now, Lordship, going ahead, DFO replies to my letter, that is at page 136. This letter has been received and he has replied.
Yes.
Now, Lordship, post this, I have my faith and trust in the government agencies, since the DFO himself has written, and this letter also, Lordship, he writes and he gives a copy to Shri Tailang Pede with regards to my reply. Now, Lordship, after this, being astonished, I write a letter.
What is the content of this letter?
Beg your pardon, Lordship?
What is the content of this letter?
136.
Yes.
Lordship, this is in reply to my letter which we have previously gone through, para 4. If I can have your Lordship's attention back to the letter which I had written, page 132, Lordship, specifically at page 133 itself again, para 5. This was the letter written by me in reply to his letter where he stated on 21st of September that there exists an overlap, thus your applications cannot be processed until the matter is sorted out. Now, Lordship, para 7 is of importance again at page 133.
Yes.
Lordship, the last line, that mention may also be made that this instant representation may also be treated as a pre-litigation notice. Now, Lordship, when I come to section 80, we will see that section 80 states that a notice under section 80 does not have to be in a fixed format. Though that is not the case at hand, but that can also be looked into. I have already written to the DFO. I have given a copy of these letters to 3 of the government agencies. This is the only government agency with whom I communicated. Based on this, Lordship, the DFO replies to my letter on 27th of October, page 136. If I may, Lordship?
Yes.
With reference to the subject cited above, it is to inform you that this office is not the competent authority to settle land dispute matters. Secondly, non-forest land certificate issued by this office does not confer any right of ownership over such land to any individual whatsoever. The purpose is purely to identify status of land as to whether forest or non-forest, as the case may be. This office, while letter number under reference had brought your attention on the incident of overlapping of proposed mining area. It is pertinent to note here that forest clearances are issued to applicants after receiving all relevant documents including proof of ownership. He goes on to state, further to address your grievance, that is of overlapping, Lordship, you are advised to approach the competent authority to deal with the matter. This is for your information and necessary action. Now again on the footnote, a copy of this letter has been sent to Tailang Pede. And there also he states with the same endorsement, information and necessary action. Now, Lordship, having received a communication from the government, having written to the government, I sat on a very bona fide belief that the government is looking into the matter and the grievance. And since the DFO himself has said that no application will be processed, copy of which has been sent to the private defendant also, thus nobody's application will be processed. In the meantime, abiding by this letter and following it that you may address the concerned authority to redress your grievance, Lordship, we wrote a letter to the sub-registrar, Lordship, page 145. If I may, Lordship.
Yes, please.
Lordship, application of non-forest land clearance certificate of the DFO. Letter number so and so dated 21/9/2022. This is the letter where the DFO first informed me of an overlap.
Yes.
Accordingly, I write to the sub-registrar. May I, Lordship?
Yes, please.
Madam, with reference to the above mentioned subject, I would like to draw your attention to the following facts and circumstances. That primarily I beg to state that the undersigned in the legal and rightful lessee of a plot of land having devolved onto me by way of a lease deed dated 19th August 2014 duly registered before the office of the sub-registrar, Southwest Khasi Hills District, Mokawat. The details and boundaries are so and so. Lordship, para 2. That on 10th August 2022, I put forth an application for non-forest land clearance certificate to the Divisional Forest Officer, West and Southwest Khasi Hills Territorial Division, Nongstoin, Meghalaya, for the purpose of limestone major mining over 40 hectares of area within the premises of the said lease area. It is also important to note that I had submitted all the necessary particulars for the process of the said application, such as the coordinate plan, Google Earth image of the area, land document, NOC from the traditional head, EPIC card, KML in CD format. That on 21st September 2022, I had received a reply from the Divisional Forest Officer, West and Southwest Khasi Hills Territorial Division, Nongstoin, Meghalaya, that the area proposed by me, which is well within the bounds of the lease property, is now apparently overlapping with the PL area limestone 20 hectares of Sri Teilang Pide. That now I am currently left in the dark about whether another instrument of registration has been illegally executed within the bounds of my lease property, leading to such overlapping of the land, and that I also cannot seem to comprehend of how is it possible for another person's property to overlap with my lease property when my lease property has been duly registered with clear boundaries being set down before the office of the sub-registrar as mentioned above. That my process of application for non-forest land certificate cannot be processed further owing to such discrepancies, and I therefore pray that your good office kindly intervenes and issues a clarification with respect to the rightful owner and leaseholder of the above mentioned landed property by clarifying from the records of your good office. Lordship, this application has not been disposed of by them. This application has never been replied to me. What do? I take a step ahead, Lordship, and I file an RTI. Page 152, Lordship. Lordship, I believe in court's copy it would be 152A.
Yes.
So type copy is there. In mine, the type copy is not there. Now, Lordship, very interestingly, this thing has been this RTI was replied to by the sub-registrar. If I have your Lordship on page 152A,
yes,
the second entry in the reply.
Yes.
Now, Lordship, my query was whether the office of the Deputy Commissioner, Southwest Khasi Hills, has initiated and opened a specific file for the queries related to Shri Albert Stephen Dingdo, if he has kindly furnished details of all the contents in the file. This is with regards to what has been mentioned at serial number 1 of this same reply, where it has been asked if any application has been received from Shri Albert Stephen Dingdo or not, to which they say yes, it has been received. The application we have just read. Now, Lordship, interesting is to see the information they have provided, serial number 2. If I may, Lordship?
Yes, please.
No specific file have been opened for the specific case. However, the same is under cross-verification by the office of the undersigned, and as the case is quite time-consuming, therefore no progress have been made till date. This is what I received from the sub-registrar. The sub-registrar also is the other government authority with whom I have communicated, and they are also seized of what is the actual issue in the matter.
Yes.
Just like the DFO. Lordship, post this, I have been waiting. Since they say that it is a time-consuming matter, it will take some time. Then state elections came up. I was waiting for the government to come up with what is the issue with my land from the sub-registrar's office, since it is the registering authority. Now, astonishingly, Lordship, despite the DFO writing that no application can be processed, copy 2 of which is for information and necessary action also given to Shri Teilang Pede, I with a bona fide belief was waiting that they are inquiring into the matter and an outcome will come out Also that the government will not process his application since government itself has stated, because of an overlap, we cannot process the applications. Now, Lordship, at page number 159,
Yes.
out of the blue, a letter dated 25/4/2023. Lordship, the dates are very important from henceforth ahead. 25th of April 2023, a letter has been issued which comes out in public circulation. Now, if your Lordship will see, this letter is in respect of the coal block allocation. At serial number 2, second column, name of licensee, Mr. Tailang Pede, allocation of Kolagaon coal block under so-and-so village, Southwest Khasi Hill district. This is that same overlap land to which my friend also over here has not denied. Now, Lordship, seeing this, page 160,
Yes.
is a newspaper article published in Shillong Times on the 2nd of May, Lordship.
Yes.
Now, this says, the type copy is at 161, Lordship.
Yes.
This is the starting. The relevant portion would be available at page 162 and 163, Lordship, the type copy of the newspaper article. The second para.
Yes.
May I, Lordship?
Please.
This is the statement given by the Chief Minister of Meghalaya. Revealing this here during the NPP campaign at Soyong for party candidate Samlin Malangyang, Chief Minister Conrad K. Sangma said that the paperwork for scientific mining will be completed within 60 days. According to the approval letter on April 24, the 4 miners cleared for mining are so-and-so, so-and-so, so-and-so and so-and-so. This is, they are referring to the letter we have just gone through at page 159, Lordship.
Yes.
Now, the Chief Minister, the government itself is saying that within 60 days the applications will be processed. Coming ahead at page 165, Lordship.
But the name,
Lordship.
yeah, the name of Tailang Pede is not here.
Lordship, I'll come to that clarification. If I can have your Lordship's attention back to page number 159.
Yes.
Lordship would again come back to entry number 1. Name of the owner, guarantor, address.
Okay.
Mr. M.S. Nongbri. And name of the licensee is Shri Tailang Pede. Lordship, because when the mining lease is given, once the government gives permission, the landowner will issue the lease that you can go and do the mining. So, what this paper article takes here, the 4 names are of the owners. But the actual person who will receive the mining lease is Shri Tailang Pede.
So this MS Nongri
Lordship.
is a landowner.
He is presumably the landowner.
Purportedly of the land,
the overlap land.
Leased overlap land of Tailang Pede.
Of my land, with which Tailang Pede
is
is land
also the
overlaps.
owner of your land.
Lordship, yes,
He is also
Lordship.
the owner of your land.
Lordship. Actually, he is the agent. The land belongs to a clan.
Clan, whatever.
Lordship. So he has both the lease deeds have been executed by him as agent of the land. Till there is no dispute. Now, Lordship, going ahead to page number 165.
Yes.
May I, Lordship?
Please.
This is on the 3rd of May. Now, the Chief Minister gives the second statement on the 3rd of May.
Yes.
He states, the centre's approval for the mining lease of 4 individuals has ignited the state's hope for reviving the once thriving mining sector. And Abya Chief Minister Conrad K. Sangma told reporters on Tuesday that the government has cleared the biggest hurdle in scientific and legal mining in the state. Once we have the public hearing, forest clearance and mining plan approved, which are procedural aspects and should take 30 to 45 days, these approvals will be given green signal for the starting of the scientific mining. Now, Lordship, this is a statement made by the government. This answers the urgency in not giving a notice of 60 days. Because the state has deceived me. The state has gone to use 2 different yardsticks for 2 different individuals. They told me that they will not process my application because of a overlap. The same overlap on my land or on Telangpede's land is not clear. I write to them that since you have said that you will not process my application, please don't process his also. That is using the same yardstick. Now, Lordship, post this newspaper article, we preferred a writ petition in the Honorable High Court of Meghalaya. Now, Lordship, the facts of that writ petition are the same as that of my title suit which I have filed in Mokarwat. The prayers made therein and prayers made herein are also identical. Now, Lordship may come to page number 68. My writ petition was not dismissed. Page 70, para 5 onwards would be the relevant portion.
Yes.
May Lordship? Heard the counsels for the parties and considered the materials on record. It is correct that the prayer as made out in the writ petition is prima facie unsustainable in as much as the same seeks cancellation of a registered lease wherein alternate remedy exists for the petitioner to seek relief in the form of a civil suit. More primarily, Lordship, specifically under the Specific Relief Act. However, notwithstanding the legal position of the case, looking into the foundational facts, Lordship, this is of paramount importance, looking into the foundational facts as to why the writ petitioner has come before this court, it is seen that it also relates to the alleged arbitrary action of the respondents in processing the permission for grant of license lease to the respondent number 11, that is Telangpede, Lordship. In spite of the objections of the writ petitioner, my letter dated 15th October, Lordship. It is further noted that by the letter dated 25/4/2022 Annexure 19 to the writ petition, the process of grant of mining lease to the respondent number 11, whose name appears at serial number 2, appears to have been processed. Mr. N. Khera, learned counsel for the petitioner, at this stage submits that the writ petition will approach the civil court within a period of 2 weeks from today to seek appropriate remedy, but however prays for some protection in the interim. In view of the matter, this writ petition is disposed of giving liberty to the writ petitioner to seek alternate remedy before the civil court. However, with the direction that status quo shall be maintained by the respondent authorities with regard to the process for grant of permission to the respondent number 11 for the next 3 weeks from the date of this order to enable the petitioner to seek such proper and appropriate remedy. Now, Lordship, why was I given a 3-week protection? Because the Honorable Court, on the face of it, saw that there is arbitrary action which has taken place. Lordship, the moment an arbitrary action takes place, urgency kicks in. It's sine qua non, Lordship. Because if the urgency does not kick in, that means we are allowing the arbitrary action to continue, which is not tenable, Lordship. Now, Lordship, post this order, we went down to the court of the appropriate court at Mokarwat and we filed our civil suit. Now, Lordship, this brings us to the main contention. Now, firstly, it has been said that I cannot file my title suit unless and until I get leave of the court, which is a wrong position of law, an interpretation of section 80, and I'll come to it also, Lordship. Now, Lordship, they have raised the contention that the court therein have ignored the judgments as quoted by them in their application. Now, Lordship, my contention is that the court in Mokarwat has absolutely and in totality followed all the judgments that have been quoted by the revisionist. Now, for that, Lordship, I would seek your Lordship's permission to take your Lordship through the judgments, though not in detail, but it will be necessary to go through those judgments. And also, Lordship, the impugned order which is being assailed herein and annexed to the petition at page 25 onwards is an incomplete order as has been given by them.
Incomplete?
The pages are missing, Lordship. Absolutely, Lordship.
Should have pointed out at the outset. Come again. Where's the impugned order?
Lordship. Page 25. And also, Lordship, one of the defendants in the lower court has not been made a party here. That is the Ministry of Mines. It's an incomplete order they have annexed, Lordship, and they are taking out bits and pieces of it to show. The court below has not wrapped up its order in one paragraph, though even if it would have done, if the order in itself is speaking order and application of mind is seen to it.
How is it incomplete?
Lordship, the order is of 13 pages. Page number 2 of the order is missing. Page number 4 of the order is missing. Page number 6 of the order is missing. Page number 8 of the order is missing. Page number 10 of the order is missing. Page number 12 of the order is missing.
Yes, Mr. Sahai, what do you say to that?
Lordship, I'm just taking a look.
Lordship, I have a certified copy of the order with me.
This is also a certified copy.
The copy that was...
It is certified copy, but pages are missing.
Yes, this is... Lordship, I did not notice this. If this is the case, I'll place the complete order.
It's a 7-page order they have annexed. The whole order is 13 pages, Lordship.
Yes, it looks like it.
Lordship, if...
If my friend would have pointed it out at the outset, I would not have pressed my arguments.
See, you should have done that. I've heard this matter for more than an hour.
Lordship.
Now they have to be given, given an opportunity to rectify this.
Lordship, I believe they have also annexed a certified copy of the order at the beginning of the petition. That's why I have not raised the issue.
That is the complete version.
In the beginning of the petition, Lordship. Not the pages where they are taking your Lordship to the annexures. Not in the annexure, it has been separately attached by them, if I'm not wrong.
Oh, yes.
That is one reason I have not raised up this issue.
Yes, Mr. Sai, what do you say?
In any event, this would not have any change so far as my submissions are concerned. So Lordship may take it that I am relying only on that one paragraph. And in rejoinder, there are a couple of points that I wish to meet. With Lordship's permission, I may be permitted to meet that. My friend can make his submissions.
Lordship, we may continue ahead. That doesn't make a difference.
Please.
I'm also more interested in whichever way the matter goes, it may be disposed of. Now, Lordship, we can come back to page number 209. May Lordship? Yes. Lordship, this was the show cause that they had filed in the court below. Now, Lordship, in this show cause, they have relied upon 5 judgments. 1964 4 SCR 945. Lordship, again, the dates of these judgments are again of importance and significance. 1964 4 SCR 945, 1966 1 SCR 986. Page 210, 11, 209, annexure P5, yes. Their reply starts, Lordship. I believe this is the last annexure of, second last annexure, Lordship. Now, Lordship, they have relied upon 5 judgments. 1966 1 SCR 986, 1964 4 SCR 945. Now, Lordship, these two judgments have got no bearing on the case at hand. They are nothing but a misleading judgment. Primary reason being that Section 80 as it stands today was amended, and the amendment came into effect from the 1st of February 1977. Prior to amendment, Section 80 did not have clause A, subsection 1, 2 and 3. If I can have your Lordship at Section 80. If I may, Lordship.
Yes.
The present Section 80 starts, save as otherwise provided in subsection 2. No suit shall be instituted against the government, including its defining the various governments. Now, Lordship, prior to the amendment, wherein the judgments of 1966 and 64 had come out, at that time Section 80 only stood as a Section 80 with no subsections, and it started without save and otherwise provided. It said no suit shall be instituted against the government without giving a notice. Now, in 1977, the amendment came, and that is the amendment with which we stand today. Subsection 1, subsection 2, which is an overrider to the provisions of subsection 1, since it begins with save as otherwise provided, and subsection 3. The rigors of Section 80 have been diluted post the amendment. Now, Lordship, having dealt with these two judgments that they had placed, which hammered the point that yes, Section 80 is a mandatory requirement, because that time there were no exceptions to it, there was no proviso to it. Apart from that, they have placed 3 judgments. I'll first deal with a judgment of 2007, Lordship. It is their judgment that they have placed. I have a copy of it. May I, Lordship? Now, Lordship, interestingly, in this judgment, state is not a party. In this particular judgment, both the parties are private respondents that they have relied upon. Okay. Since the issue is between private respondents, Section 80 doesn't have any material bearing. Now, but Section 80 has been mentioned in this judgment only as a passing example, comparing it with to the other provisions of law. It has got no bearing on the case. The second judgment that they have relied upon, that is important, Lordship. That is a judgment of 2013 10 SCC 178. This is an important judgment. 2013 10 SCC 178. These are their judgments, Lordship.
Yes.
Lordship, para 19, para 20 and para 21. Page 183, Lordship,
yes,
of the judgment. May I, Lordship?
Please.
Now, Lordship, what had happened in this particular case, the fact of this particular matter was that the plaintiff herein had filed a suit, and he had filed an application under Section 82 for waiving the rigors of Section 80, subsection 1 of Section 80. However, the court below took the application, placed it on record, did not dispose it of, and proceeded with the suit. So this judgment primarily says the essence of 82, how is it to be processed? Our case is not the same. Our case is that my application has been disposed of. So, Lordship, para 19 onwards, it is an admitted fact that no order had been passed on the application filed under subsection 2 of Section 80 CPC, whereby leave of the court had been sought for filing the suit without complying with the provisions of Section 81 CPC. In our opinion, a suit filed without compliance with subsection 1 of Section 80 cannot be regularized simply by filing an application under subsection 2 of Section 80. This is what they have quoted in their petition. But we'll have to go ahead to see the complete paragraph, Lordship. Upon filing an application under subsection 2 of Section 80 CPC, the court is supposed to consider the facts and look at the circumstances in which the leave was sought for filing the suit without issuance of notice under subsection 1 of section 80 to the government authorities concerned. For the purpose of determining whether such an application should be granted, the court, Lordship,
Yes.
the court is supposed to give hearing to both the sides and consider the nature of the suit and urgency of the matter before taking the final decision. By mere filing an application, by no stretch of imagination can it be presumed that the application is granted. If such a presumption is accepted, it would mean that the court has not to take any action in pursuance of such an application, and if the court has not to take any action, then we fail to understand as to why such an application should be filed. Para 20. It is an admitted fact that no order had been passed on the application filed under subsection 2 of section 80 CPC till a final order is passed granting the said application. In our opinion, the irregularity in filing of the suit continues. If ultimately the application is rejected, the plaintiff is to be returned, and in that event the application filed on behalf of the appellants under Order 7 Rule 11 CPC is to be granted. If the application filed under subsection 2 of section 80 is ultimately granted, the objection in regard to non-issuance of notice under subsection 1 of section 80 CPC cannot be raised, and in that event the suit would not fail on account of non-issuance of notice under subsection 1 of section 80 CPC. We reiterate that till the application filed under subsection 2 of section 80 CPC is finally heard and decided, it cannot be known, Lordship, the second aspect, whether I could have filed the suit or not. It cannot be known whether the suit filed without issuance of notice under subsection 1 of section 80 CPC was justifiable. According to the provisions of subsection 2 of section 80 CPC, the court has to satisfy, after hearing the parties, that there was some grave urgency which required some urgent relief, and therefore the plaintiff was constrained to file a suit without issuance of notice under subsection 1 of section 80. Lordship, there are three things which this judgment says. Primarily, it says that mere filing of an application is not sufficient enough. The application has to be heard and disposed of. In my case, once I filed the application, notice was issued, the concerned government departments, they entered appearance, show cause were filed, a hearing took place, and Lordship, not just a hearing, they themselves have admitted in their plaint, in their revision petition, in fact, Lordship, at page 9, that the matter was heard at length. They say, the revisionist department filed its show cause to the interim application on 7/6/2023, and the application under subsection 2 of section 80 was heard at length by the court. Consequent to it, the court disposed of the matter. Now coming to section 80, Lordship, and I will be culminating my submission. I'll only take your Lordship to 115, the provision of law under which they have come, and I'll culminate. Now, Lordship, the third judgment which they relied upon,
but that still does not answer your filing the plaint simultaneously with the application.
Lordship, the same judgment which I have referred to right now.
It talks about an application, but not necessarily the plaint.
Lordship, it says, para 20, it opens up with it, Lordship. It is an admitted fact that no order has been passed on the application filed under subsection 2 of section 80 CPC. Till a final order is passed granting the said application, in our opinion, the irregularity in filing of the suit continues. What it means, Lordship, that once I have filed my suit has not been regularized. That is why your Lordship will see, when the court below had issued the notice, which my learned senior here has brought to the notice of your Lordship, that notice does not require them to file a written statement, because the suit has not been regularized. That notice only tells them of the information that a suit has been filed. Along with that notice, a secondary notice went, in which my application under subsection 2 of section 80 CPC was also there. Because this application is to regularize my title suit, my plaint, so it cannot be filed independent, Lordship. Had it to be filed independently, I would have to go on to the administrative side of it, Lordship. That is why we filed it in the court. So to say, it is like a limitation application, Lordship, which I filed with my suit. My suit is defective and has not been regularized. till the application under section 80 is disposed. Now this particular paragraph goes on to say, if the application under subsection 2 of section 80 is rejected, my plate has to be returned. The same paragraph says. However, if this application succeeds, then my suit gets regularized. I hope I have satisfied your Lordship on this aspect. Now, Lordship, going ahead, coming back to this particular judgment, 2006-12 SCC 119. This is the last and final judgment that my learned friend here has relied upon.
Yes.
So in fact, Lordship, during the hearing of my subsection 2 section 80 application, I was helped by him. I did not have to rely upon any judgment. And why? We'll come to it, Lordship. Now, Lordship, before we go into this judgment, may I have your Lordship to section 80? We can read it once. May I, Lordship?
Yes.
Section 80, notice. Save as otherwise provided in subsection 2, no suit shall be instituted against the government, including the government of the state of Jammu and Kashmir, or against a public officer in respect of any act purporting to be done by such public officer in his official capacity until the expiration of 2 months next, after notice in writing has been delivered to or left at the office of A, B, BBC. These are the people they have stated, Lordship. Now, Lordship, interesting part is the beginning. Save as otherwise provided by subsection 2. No suit can be instituted prior to giving a 60-day notice. I am in agreement. But to understand how will subsection 1 come into play, we'll have to read subsection 2. Because that is the rider which comes with subsection 1, Lordship. Now, subsection 2 states, a suit to obtain an urgent or immediate relief against the government, including the government of the state of Jammu and Kashmir, or any public officer in respect of any act purporting to be done by such public officer in his official capacity, may be instituted with the leave of the court without serving any notice as required by subsection 1, but the court, Lordship, this is again a rider to it, but the court shall not grant relief in the suit, whether interim or otherwise, except after giving to the government or public officer, as the case may be, a reasonable opportunity of showing cause in respect of the relief prayed for in the suit. Lordship, having gone through this section, I'll draw your Lordship's attention to the judgment I have placed. Again, their judgment, 2006-12 SCC 119.
Yes.
Lordship, para 14, page 125, judgment.
Yes.
May I, Lordship? From a bare reading of subsection 1 of section 80, it is plain that subject to what is provided in subsection 2 thereof, no suit can be filed against the government or a public officer unless requisite notice under the said provision has been served on such government or public officer, as the case may be. It is well settled that before the amendment of section 80, the provision of unamended section 80 admitted of no implications and exceptions whatsoever and are express, explicit and mandatory. The section imposes a statutory and unqualified obligation upon the court, and in the absence of compliance with section 80, the suit is not maintainable. See so and so, so and so. These are the two judgments which I referred already, Lordship, of 1964 and 66, the pre-amendment. It goes on, the service of notice under section 80 is thus a condition precedent for the institution of a suit against the government or a public officer. The legislative intent of the section is to give the government sufficient notice of the suit which is proposed to be filed against it, so that it may reconsider the decision and decide for itself whether the claim could be accepted or not. As observed in Bihari Chaudhary, the object of the section is the advancement of justice and securing of public good by avoidance of unnecessary litigation. Para 15. It seems that the provision did not achieve the desired results, in as much as it is a matter of common experience that hardly any matter is settled by the government or the public officer concerned by making use of an opportunity afforded by the said provision. In most of the cases, notice given under Section 80 remains unanswered. In its 14th report, reiterated in the 27th and 54th reports, the Law Commission, while noting that the provision of this section had worked a great hardship in a large number of cases where immediate relief by way of injunction against the government or public officer was necessary in the interest of justice, had recommended omission of the section. However, the Joint Committee of Parliament, to which the Amendment Bill 1974 was referred, did not agree with the Law Commission and recommended retention of Section 80 with necessary modifications/relaxations. Thus, in conformity therewith, the Code of Civil Procedure Amendment Act 1976, the existing Section 80 was renumbered as subsection 1 of Section 80, and subsections 2 and 3 were inserted with effect from 1/2/1977. Subsection 2 carved out an exception to the mandatory rule that no suit can be filed against the government or a public officer unless 2 months' notice has been served on such government or public officer. The provision mitigates the rigors of subsection 1 and empowers the court to allow a person to institute a suit without serving any notice under subsection 1, in case it finds that the suit is for the purpose of obtaining an urgent and immediate relief against the government or a public officer. But the court cannot grant interim relief under subsection unless a reasonable opportunity is given to the government or public officer to show cause in respect of the relief prayed for. The proviso of the said...
This will come after the application has been allowed.
When I filed the application, the 2013 judgment we went on to just now, Lordship, prior to this, it says that the hearing opportunity.
Hearing opportunity, yes. So eventually the application under 82 will be disposed of.
Lordship.
In the meantime,
Lordship,
the government or the parties are not to seek relief until you allow the government to show cause. So that is the different aspect.
Lordship, no ex parte order will be passed. And no ex parte order has been passed.
Yes.
What they are coming on balance of convenience and prima facie case, my learned friend, it is not in the ambit of this particular revision petition. Because I'm sure Lordship is aware that the jurisdiction and the ambit of the revisional jurisdiction under 115 of CPC is very limited to the 3 conditions which are there. That will be my concluding part where I'll go to Lordship. If permitted, there are any further just 2 paragraphs are there if I may complete them. They are of much importance. May I continue, Lordship, that same para 16?
Please.
Lordship. The proviso to the said subsection enjoins that in case a court is of the opinion that no urgent and immediate relief should be granted, it shall return the plaint. Lordship, again it says, return the plaint. That means I will have to file the plaint for it to be returned, along with my application under subsection 2 of section 80. For presentation to it after complying with the requirements of subsection 1. Subsection 3, though not relevant for the present case, seeks to bring in the rule of substantial compliance and tends to relax the rigors of subsection 1. Now, Lordship, when we see subsection 3, it will say that the letter which I had written to the DFO on the 15th of October, where I have stated that it is a pre-litigation notice, and also the letter which I had written to the sub-registrar, it contains my specific name, I can be identified, it has the basic subject matter. These are the 2 subject matters. One is that please don't process his applications, and 2 is cancel his lease deed. So, subsection 3, if we go into, it unshackles me from the rigors itself. But though that not being the case, I have come under subsection 2 and the compliance has happened. Lordship, para 17 and 18 are the last 2 paragraphs in it. Thus, from a conjoint reading of subsections 1 and subsection 2 of section 80, the legislative intent is clear, namely service of notice under subsection 1 is imperative, except where urgent and immediate relief is to be granted by the court, in which case a suit against the government or a public officer may be instituted but with the leave of the court. Leave of the court is a condition precedent. Such leave must precede the institution of a suit without serving notice, even though subsection 2 of section 80 does not specify how the leave is to be sought or given, yet the order granting leave must indicate the grounds pleaded and application of mind thereon. A restriction on the exercise of the power by the court has been imposed, namely the court cannot grant relief whether interim or otherwise. except after giving the government or a public officer a reasonable opportunity of showing cause in respect of relief prayed for in the suit. Now, Lordship, the whole issue at hand has been summed up in para 18. The whole issue of this instant litigation. Having regard to the legislative intent noticed above, it needs little emphasis that the power conferred on the court under subsection 2 is to avoid genuine hardship and is therefore coupled with the duty to grant leave to institute a suit without complying with the requirements of subsection 1 thereof, bearing in mind only the urgency of the relief prayed for and not the merits of the case. More so, when want of notice under subsection 1 is also made good by providing, and even in urgent matters, relief under this provision shall not be granted without giving a reasonable opportunity to the government or a public officer to show cause in respect of the relief prayed for. The provision also mandates that if the court is of the opinion that no urgent or immediate relief deserves to be granted, it should return the plaint for presentation after complying with the requirements contemplated in subsection 1. Lordship, the judgments in essence says that if the court below sees that there exists an urgency, it will use its own independent mind. And if the court is satisfied that an urgency exists, it will do away with the rigors of subsection 1. However, in such event also, no ex parte order, interim or otherwise, will be passed against the government without affording them an opportunity of being heard. And in such scenario, the basic ingredients of subsection 1 are also met with. So these were the 5 judgments that they had brought out. Now, but I again fail to understand that whatever has been defined in these judgments is what has been followed by the court below. Now, Lordship, that will bring me to section 115, right? Last part of my argument. Revision, Lordship. Where are the judgments?
Yes.
Lordship, while this exercising jurisdiction under 115, we will have to abstain from going into the absolute facts of the matter or into the merits of the case or appreciating anything that exists on record. What is to be seen are 3 things, Lordship. The first thing is, did the court below exceed in exercising its jurisdiction? The second thing is, did the court below abstain from exercising the jurisdiction vested in it? And the third thing is, has there been material irregularity? Now, Lordship, the first and the second part are extinguished because it is the court below who solely has the original jurisdiction to take up this matter and try it. So neither has the court acted beyond its jurisdiction or below its jurisdiction. If it is not the trial court below, then they will have to state which is the appropriate court. The last part, that is the material irregularity, Lordship. Now, Lordship, material irregularity in the very simple layman's term will mean the travel to reach a destination. Now, the destination is not of the essence or of consideration with us. It is the journey. Thereby meaning the procedure adopted to reach to the conclusion or to the order has to be seen. If the procedure is in conformity with law, 115 does not exist, Lordship. There are a few judgments Now, Lordship, to understand if we have the court below has followed procedure or not, yes, the judgments which we have gone through, specifically the judgment of 2013 and 2006, they very categorically state the procedure basically. With my suit, an application under subsection 2 of section 80 has to be filed. My suit is irregular till the application has been disposed of. If the application has been disposed of in my favor, my suit gets regularized. If the application of mine is dismissed, my suit is returned. That I should comply with the rigors of subsection 1 and come back. Now, court below received my plaint, received my application, issued notice to the parties concerned. They were given adequate time to come. They came, they did a very lengthy hearing. It is in their own revision petition. And after that, the court below passed an order. So the procedure to arrive at the order is correct. The issue will not be here, Lordship, to go whether the order is right or wrong, whether the facts endorsed in the order are right or wrong. What has to be seen is the procedure in material irregularity if we have travelled or not. Now, Lordship, this particular judgment, paragraphs 20, 21, 22, 23, 24, 25 and 26 Lordship, from para 21 till para 25,
Just a moment.
various judgments have been referred.
Just a moment.
Lordship.
Let me note it down. You're quoting para 20 to 25?
Para 20 till 26.
26.
Lordship.
Yes.
Lordship, from para 21 onwards, various judgments, landmark judgments given at various points of time have been quoted by their lordships therein, and at para 26 they have summed up. So
yes.
May Lordship. Illegal and material irregularity do not cover either errors of fact or law.
You are reading?
Para 26, Lordship. Second line.
Yes.
I have your Lordship at para 26.
Yes.
Lordship, they have summed up all the other judgments that they have referred to from para 21 onwards. And they say, illegal and material irregularity do not cover either errors of fact or law. They do not refer to the decision arrived at, but to the manner in which it is reached. The errors contemplated relate to material defects of procedure and not to the errors of either law or fact after the formalities which the law prescribes have been complied with. So they will have to show, Lordship, either procedure was not followed or court did not have jurisdiction for this petition to be maintainable in its present form with the pleadings that it contains. Now, Lordship, there are various other judgments that have relied upon this judgment and subsequent judgments. I would like to place one last judgment. Similarly, Lordship, from para 5.
Yes.
Till para 12. Lordship, in this judgment, it also, para 5 till para 11 onwards, all the landmark judgments, including the judgment I have placed before this judgment to Lordship, has been referred to right from 1894, and at para 12 their lordships concluded. So we can only go through para 12, Lordship.
Yes.
Such case. Page 179. May I, Lordship?
Please.
The position that emerges from the decision, from these decisions, is that Section 115 of the Code of Civil Procedure empowers the High Court to satisfy itself on 3 matters. A. That the order of the subordinate court is within its jurisdiction. B. That the case is one which the court ought to have exercised its jurisdiction and failed to do so. C. That the exercise of the jurisdiction, the court has not acted illegally, that is in breach of some provision of law or with material irregularity by committing some error of procedure in the course of the trial, which is material in that it may have affected the ultimate decision. And if the High Court is satisfied that there is no error in regard to any of these 3 matters, it has no power to interfere merely because it differs from the conclusion of the subordinate court on question of fact or law. It goes on, Lordship. 115. Now, Lordship, my urgency began when different yardsticks were used to process one's application and not mine. That urgency got extended, Lordship, when the Chief Minister of the state gives a statement that 60 days or 35 to 45 days, the permissions will be done. My learned friend is here, my learned senior here has said that the applications are in the advanced stage of processing. Now, what does Section 80 state, Lordship? It states that once I bring it to the notice of the government authorities, they have to do something about it. They are in notice of it right since the 18th of May when I filed my writ. And they are saying that the applications are in the advanced stages of processing because there is no stay. That is the submission made by my learned friend here at the bar. Well, it would have been appreciated if they would have said that yes, they are looking into the matter. And my urgency got absolutely endorsed, Lordship, when the Honorable High Court of Meghalaya stated that on the face of it, there is arbitrariness and arbitrary action on the part of the state respondent authorities in processing the application of respondent number 11, that is Tailang Pede, and in not processing my applications, despite me raising my protest to it in the form of the letter dated 15th October. Lordship, I'll conclude, but it will again be very important to go through actually the order which none of us have taken your Lordship through, which is impugned here. Lordship, the certified copy I have placed because their pages are missing.
Yeah, no, it's here. It's here on the record.
Lordship. May I, Lordship?
Yes.
Lordship, this order spans 13 pages.
Yeah.
Wherein they have brought before your Lordship that the court has summed up the whole proceeding, whole of its order in one paragraph. That is not fact, Lordship. The court has gone over 5 pages in that order. In fact, from page number 9, if I can have your Lordship's attention drawn to it, page 9 of page 13.
Yes.
May I, Lordship?
Yes.
It says, third paragraph, Lordship.
Yes.
After hearing the learned counsels, this court perused section 80 of the Civil Procedure Code, and which reads as follows. The court starts its order from here. If the court has not applied its mind, I believe the court would not have firstly perused section 80, under which my application rests. Court goes on, Lordship, to go into the basic details. At page 13, when the court concludes, second last paragraph, Lordship.
Yes.
The court uses one particular word which shows the application of mind in it. If I may, Lordship.
Yes.
The last line, it says, involves minerals such as limestone and coal.
Last line of what?
Third last paragraph, last line, Lordship. Second last line of third last paragraph.
Yes.
May I, Lordship? Involves materials such as limestone and coal, which are classified as non-renewable in nature.
Yes.
It goes on, after hearing the learned counsels, that is from page 1 till page 9 of its order, Lordship.
Yes.
Without going into the merits of the instant case, and in view of the discussions above, the court formulates its opinion. Now, Lordship, where has it been without application of mind? Where has the order been summed up in one paragraph? The court has gone in detail. Among other things, only thing I'm pointing out to your Lordship is the kind of substance which exists, the subject matter basically, are non-renewable in nature. And Lordship, I ask myself a question and I fail to understand. Is the state trying to say that something illegal should go on and it should continue? And if it is found that no, I was right and it is wrong, then they will ensure that I am compensated in monetary terms. Now, Lordship is sitting in a bench where the PILs with regards to coals are being taken up. The primary reason is that they are non-renewable, Lordship. So they cannot be abused. So the contention that let the permission of the Ilangpete go on and the desperation with which the state is coming ahead. First, the state is using a different yardstick with him. Now it's saying that let his permission go on. Whatever loss will happen in the depletion of coal or otherwise in the land, if I win my case, it will be compensated. Who will compensate? So are they trying to say, Lordship, the arbitrary action which the Honorable High Court on 18th has observed and endorsed upon it and has given me time to go to the appropriate court to seek appropriate remedy, and until then a protection was given to me? Are they saying that that view of the Honorable High Court of Meghalaya is also... I'll rest my submission on this, Lordship. They have not made out any case of revision. The order is in conformity with law. All procedures were followed. It is their judgment which I have quoted. I have not come out with any new judgments which they have relied upon.
Who are the other respondents here?
Lordship, others are private respondents. I wish to seek some time for a rejoinder. I'll not take more than 15 minutes of lecture.
Just a moment, Mr. Sai.
Yes.
If the other respondents would like to address the court.
Lordship, the private respondents have got no say in the case because it is against the... No, Lordship...
True. But they have been arraigned.
Yes.
But just one sentence, Your Lordship. Your Lordship, I'll take Your Lordship to page 159, which my learned friend has been reviewed by this particular provision. Page 159.
Yes. You are for respondent?
Respondent number 2. Ilangpete, Your Lordship.
Yes.
I'll read, Your Lordship. Subject: previous approval of central government for grant of mining lease. Sir, I am directed to refer to government of Meghalaya. I am directed to refer to government of Meghalaya letter so dated 12/9/2022 on the above subject and to convey previous approval of central government under Rule 42(2) of the Mineral Concession Rules 1996 for grant of mining lease to the following applicants. Now, Your Lordship, my applications was already processed way back in 2020. It ended up in the month of June in 2021 when the entire procedures were completed. Then the state government has forwarded the same to the central government on 12/9/2022. My applications are already on process. It's already gone to the central government for hearing. Now, the cause of action, which from their pleadings in the plain says it's 22nd September 2022. Now, 22nd September 2022 is what they have pleaded in the plain, that the cause of action arose on 22nd September 2022. Now, because of the letter written by the DFO. Now, when my applications are already gone to the central government, it's deemed fit for the DFO to reply to them saying that he is not a competent authority to decide these issues. You go and approach the competent authorities, which they've not done so. On September, when they had the cause of action to either file Section 80 or file a suit right there immediately to dispense with the service of Section 80, but they have not done so. Instead, they were busy writing letters. Waited till April after this particular letter was issued. My application, can you read, 12/9/2022 has already been sent before they came to learn about the overlapping. Because why? The reason is that I have applied much more earlier than that. My process already started in 2020, Roger. They started the application only in 2022. So that's why there's no urgency to dispense with Section 80.
See, but as far as you're concerned, and as far as the respondent number one or the plaintiff for that matter is concerned, it is an issue of settlement of your right, title and interest and the lease over the said land. So to that extent, the court has to go into the facts, has to look into the evidence and so on and so forth, which only the trial court can do.
This court at the manner in which, but my rights also be affected because I have applied with due process under law, Lordship. I also will be affected. It's not that only his case. First, the facts have been linked to which the trial court needs to look into all this. But the basic, essential, what is essential before this court is that whether Section 80 has been complied with or not.
That is the question. That is the focal question here.
Granted or not.
That is the focal question here.
Because my blood has been harping on the urgency that there are arbitrary actions. There's no arbitrary actions. The DFO has clearly spelled out that, please, he does not have to tell him you go and file a suit in Maukarwadi. He has indicated in the letter that, please, you go to appropriate authorities, get your grievances addressed. Because he can't decide. But they waited from September till April of that.
Who are the other respondents?
Respondent number 3. What I want to say is, I'm the agent of the landowner to execute the lease deed in favor of the private respondent.
So you have nothing to say.
No.
And who's appearing for?
Remaining are all state only. State is on both sides.
State is on both sides.
Revisionist also state, respondent also state. Not central, state is also there.
4, 5, 6, 7, 8, 9 and 10. They are state entities, Mr. Sai.
Yes, Lordship, 9 will be a separate statutory authority. 9 is the State Pollution Control Board.
9.
They will be a separate statutory authority. I do not hold brief for them.
Who is appearing for 9?
Lordship, the Pollution Control Board has not appeared even once, right from the time when the writ was filed.
Oh.
They have however, the remaining respondents were represented by Mr. Sahai only back in the.
Mr. Sahai, if you have read respondent 9 in this petition, have you issued notice upon them?
Lordship, 9 has been made a party in this because they are parties to the suit.
No, whatever the case may be, whatever the case may be, you have read them as one of the respondent. So it stands to reason that notice has to be issued to them. Whether they, they participate in the proceedings or not, that's up to them. This also should have been.
Lordship, I'll have to take instructions.
No, but this is this has. Now the court cannot pass an order.
In fact, they may be struck out.
How are you to say that they will be struck out?
They did not participate
Whatever
in
the
the
case may
proceedings
be,
down there.
you are not the petitioner here.
Lordship.
It's for a petitioner to say.
Lordship, to assist this court, because today the matter has come up for the first time in motions here. Now, if this court issues notice to Pollution Control Board, then they can take steps.
The court is of the mind to dispose of the matter today.
But if it's come for the first
With the 3 hours we wasted here only for that. These things should have been pointed out, Mr. Sahai, at the outset.
Lordship, even I was of the view that perhaps Lordship is considering editing the matter. Now that it's been heard at length, of course, Lordship would be inclined to pass an order in the matter. But that's why I restricted myself as far as possible to only the issue of Section 80. My friend had gone into the merits of the case, showed Lordship letters, but
Exactly.
I was of the view that since this is for admission, I would keep it limited to that.
What you can do, Mr. Khera, or even Mrs. Sai, whatever you have submitted, if you can just, reduce it in writing, form of a written synopsis or bullet point argument, that will be helpful for the court. Otherwise, I will not be, if the respondent 9 comes and I have to hear you again, the whole thing has to be heard again. So we'll wait for the respondent 9 to appear. And in the meantime, your submission will be on board and that will be taken into account.
Yes. Would Lordship permit me a rejoinder today or on the date respondent number 9?
I think we'll do it later then. Let the respondent 9 come in the picture and then we'll see.
If I'm right to understand, Lordship would be interested in receiving gist of our arguments which we have
that will be better. Otherwise, now I will have to hear you again the next time around.
So hearing is done, Lordship, from our side.
Basically, it's done, except we'll see what the respondent 9 says.
As well.
Yes, you'll be allowed to do it.
The suit is filed is fixed on Monday.
Lordship, that suit may go on. There is no stay. They have filed a revision petition here. This matter is to be taken up for disposal. That suit may go on because I have an urgency. No, let me complete, sir. Let me complete. I'm giving a submission. Lordship, that suit is going on. Now, on the last date also, and on a date before that also, they have used the guise of this revision petition being filed in this Lordship's court, and we have not done any hearing.
Absolutely.
I will show the order, Lordship.
I'm sorry,
Mr. Khera, but that is the whole issue is that if this revision perhaps is decided in favor of the petitioner,
Lordship,
then your whole suit goes.
Lordship.
So if the suit is allowed to go, it will be futile.
Lordship.
Even for you. So,
but Lordship, I have one apprehension.
What you can do is, perhaps finally the court has to issue a status quo.
Because Lordship, they have made a submission at bar that the applications are being processed. And here I am being tied not to proceed with my stay application because my stay application is a secondary step. Right now the court will be on the 10th. When the matter is fixed, it is fixed for the court to hear the application filed by them under Order 7, Rule 11 for rejecting my plaint. So my interim application is not being heard on the next date.
Okay. Yeah, you have said that on the last occasion.
Yes, Lordship. I will show the order of the last. I'll place the order. We have taken a certified copy of the order dated 3rd. It is categorically mentioned on submissions being made by the central government and the state government. And I also agreed to it that the application, miscase number 1, which is for the interim injunction, that may be heard on a later date. No date has been fixed. Only 10th has been fixed if they have to file show cause, if any, in that application. However, it has been fixed on the 10th for hearing of their application under Order 7, Rule 11. No. This is the
just a moment. Let it fix.
This is a certified copy of the order of the 3rd, Lordship. So if they succeed in their 711 also, my suit is gone.
Lordship, if I may, my friend would appreciate that on the last occasion.
And Lordship, this is the order. This is the order in the miscase.
Just my friend.
Yes, please.
There is no dispute about orders of the trial court. I am suggesting something that would perhaps make life easier for my friend. On the last occasion, it is because my friend was indisposed and was appearing in caveat that the matter was accommodated to today. And therefore, a statement was fairly made by them that they will not pursue before the trial court. Now, if Lordship is adjourning it for the appearance of respondent number 9, Lordship may give short notice. We are not opposed to that. We have not opposed on any date. We have not sought any adjournment before the trial court. We are actively appearing before it. A short notice may be given till that date, they may not pursue the matter before the trial court. Ordinarily, it stands to reason that the statement should come from my learned friend. There's no requirement for an order of the court also, because otherwise he should give that statement that he will not pursue before the trial court till the matter here is pending.
Lordship,
And Lordship has heard the matter. We will file
ironically on
it
the
could
10th,
close
it
on
is
an
their
early date.
petition which is.
Yeah, so now okay, let's put it this way. Now submission has been made at the bar that they will not press that petition as on the 10th. So, so the situation will remain.
So, Lordship, in that case, no order may be passed to that effect for being interpreted either way. This matter may be fixed with a short date.
So, we'll do that.
Monday?
As has been suggested by Mr. Sai, we'll do that.
Lordship, Monday?
Can you do it by Monday, Mr. Sai?
He said.
Lordship, I will ensure service by then, and Monday is. But written submissions, Lordship may grant till Wednesday if it's. Because copious arguments I would like to rejoin also in writing. Till Wednesday if it's
so we'll fix the matter on Wednesday then. To us.
Right.
Lordship, final disposal Wednesday. Humbly pray.
If we can.
I am desperate, Lordship, but the situation has made me desperate in the matter. Nothing else.
Like Mr. Sai has said, see, heaven will not fall.
Because he's saying that they are in the advanced stages because there is
that has been made clear at the bar, and it would be incumbent upon them to restrain themselves.
Gotcha.
Not necessary to pass for an order to be passed, but it is incumbent. If at all any adverse action is taken by them, you have a right or you have a remedy,
gotcha.
And the court will look into it, unkindly or kindly, whatever the case may be.
I might be over ambitious, but I'll still make a prayer in the interest of my client. Case. A small observation that they may also not proceed ahead until this revision is disposed.
Well, we'll wait for the next date and see how it goes. From there, if nothing materializes, then next day orders will be passed.
Lordship. Yes. Obliged, Lordship.
Heard learned counsel for the petitioner. Heard Mr. Sahai, learned G appearing for the petitioner. Also heard Mr. N. Kira, learned counsel appearing for the respondent. Number
1, Lordship.
1. The respondent number 2, 3, 4, 5, 6, 7, 8. What, Mr. Sahai? You're also holding brief for respondent 4 to 8. Can you do that? Can't hear you.
I can hold brief for them, Lordship. Respondents 4, 5, 6, 7, and 8, and 10.
Can you?
They may be pro forma respondents.
Can you?
As such, they are pro forma respondents.
You are the petitioner.
They are pro forma respondents in essence, Lordship. They are not contesting the case.
Whatever the case may be, has notice gone out to them?
Lordship made
nothing is stated here.
Issue notice.
Nothing is stated here that they are pro forma respondent.
I quite see that difficulty will then.
And I can't see, Mr. Sahai, I can't see the logic why you are saying that on one hand you are appearing for the petitioner and also appearing for respondent. Can you do that?
For the no, Lordship will leave it at that. Lordship can then issue notice, and on Wednesday I'll ensure that some other GA enters appearance on their behalf. Otherwise, it would be rather confusing.
I thought we are having a new jurisprudence where you can. Okay, I'm not saying more than that. Kununto, respondent 2 and 3, as well as respondent 10, 11 and 12, as well as respondent 11 and 12 are being represented by their respective counsels. However, the petitioner is is directed to take steps for issue of notice upon the respondents 4, 5, 6, 7, 8, 9 and 10 respectively.
Lordship, also Ministry of Coal, Ministry of Mines. They have not made a party.
It's for them. It's for them too. It's not your case.
Is a defendant in the suit matter.
But not in the revision.
So we'll see how it will affect them. More often than not, I don't think.
No, Ministry of Mines doesn't have a role also.
On pre made by the parties, let's this matter on 12th.
Obliged, Lordship.
Item number 2.
Deeply over.
May I please, Lordship? I am appearing for petitioner number 1.
Petitioner number?
Simeon.
How many?
Two petitioners were there, Lordship. And in this, petitioner number 1 wants to withdraw from this proceeding, Lordship. And an application has already been filed.
You are not appearing for both petitioners?
No, Lordship. Mr. Sanglaisu had been appearing for.
I'm appearing for both, like previously, but now since they have filed, we have received copies of their application for withdrawal. We have no objection. From now, we'll be appearing for Shri Grain Liwell Kharsao.
For number 2. So an application has been filed which has been registered as Miss Case number 145. I have sought the copies.
Lordship, may I submit?
Yes, Mr. Contempt.
I am of the view that that application for withdrawal may be taken up first, then later we can.
Why would you? What would be your objection, Mr. Kanta? Since the petition.
At the end of the day,
petitioner
the writ petition will become infructuous here, Lordship.
Why?
According to me, the petitioner who has sought to withdraw himself has also made a statement at paragraph 5 saying that they does not want to pursue with the writ petition.
No.
And
as petitioner number 1.
Yes, Your Honor.
Yes, as petitioner number 1. So only the petitioner number 2 will remain.
Yes, Lordship.
And if he wishes to pursue, then
yes.
So be it.
Yes.
TK will go ahead.
Heard Mr. S.D. Upadhyay, Learned Counsel for the petitioner number 1. The Learned Counsel has submitted that the petitioner number 1 does not wish to pursue this matter any further as far as he is concerned. In this regard, and as such, through this application, prayer is made that he may be struck off from the arrays of parties herein. Since respondents has no objection to the prayer made, accordingly, the petition is allowed and the petitioner number 1 is hereby struck off from the rules of this of the parties herein. Miss Case number 145 of 2023 is hereby disposed of. The counsel for the petitioner number main case memo. The counsel for the petitioner number 2, on the other hand, has submitted that he wishes to pursue the matter. Next. So we are on the affidavit, counter affidavit.
Worship
You're supposed to
respondent.
file the rejoinder, and I'm supposed to file one small additional.
And the Mr. Counsel?
We've already filed it.
Fine. Have you filed rejoinder?
And we bring for some more time.
The Learned Counsel for the petitioner number 2 has submitted that he may be allowed to file the rejoinder since the same could not be filed today. As prayed for, this is matter of the 2 weeks. Pray aloud mo to kaya to join.
Item number 4.
May please, Your Lordship.
Yes.
Lordship, these are those NEHU matters. And this item number 4 is the one which Your Lordship was pleased to release from CAV.
Yes, yes. So basically, I think 4 has been heard, but then what do we do?
So, Lordship, we are waiting for something to fall from Your Lordship in what manner we can assist this Honorable Court regarding item number 4. Because the matter was heard at length and we have also filed our written submissions also, Lordship.
What we can do, Mrs. Sen, what we can do here, we can keep this this petition on hold for a while, since matter has already been heard.
My Lord, again I pray, my Lord, all this confusion started because right from the beginning I am saying, my Lord, if we can decide this, because other matters are more or less similar. These are all revolves around 2 schemes, exactly. MSCP, SCP. So, my Lord,
what is the assertion of
this has been, my Lord, there is a reason why it has been released. It was listed last occasion to be spoken to. So, I made a submission, my Lord, that since long time has elapsed, whatever it may be, it requires a fresh hearing. That was my whole contention. So, my prayer will be, my Lord, since the other matter revolves around the same schemes, and which is involved here, my Lord will hear it afresh. That will be, my Lord. I feel Lordship will also file convenient, my Lord, it will be convenient for all.
Yeah, what about the
other thing, my Lord, once Lordship decides this, my Lord, right from the beginning I am saying, my Lord, once Lordship, otherwise there will be a lot of...
So the principle will be more or less the same?
More or less same, Your Lordship.
Except
so Lordship
for...
will, my Lord, my humble submission, Lordship will, my Lord, concentrate on this, Your Lordship. And after, my Lord, this is decided, my Lord, I don't think other writ petition, there will be any difficulties, Your Lordship. So this needs to be decided, my Lord.
Yes, Ms. Paul.
Lordship, this is what I fail to understand. Lordship, this matter was reserved by Your Lordship after hearing us at length. My learned friend, Mr. Sen, says that this needs fresh hearing and it was released from CAV on that count. Now he says the same matter is to be reheard. So I am not understanding what he's actually trying to say. Actually, I completely fail to understand his contention. Because, Lordship, if all the matters are similar, then one matter has been heard, all the matters also are similar, so all can be reserved for judgment, Lordship. And if the matters are different, then each merits a hearing. So on this, if my learned friend can make his stand clear, it will be easier to...
What could be understood? What could be understood is perhaps as Mr. Sen has submitted, the general principle will revolve around this particular suit, particular petition. Whereas in the other petition, some variation would be there as far as maybe facts are concerned. So on that, you need to address the court on that.
Lordship, I will make one line submission in this regard. Now, what my learned friend is trying to say that it is on the same issue. Admittedly, Lordship has, I think by now, we have been able to place before your Lordship that they are very different. The first matter which was reserved for judgment, Lordship, it is only for not availing the upgradations as given under ACP and MSCP. His case is that. Simply put, Lordship, that under ACP and MSCP, he was entitled to 3 upgradations. He has not got it. Simply put, that's the case. Whereas the other matters, Your Lordship, it's an admitted fact that they have got all the upgradations. But they are fighting for the pay scale due to a different pay band. So it has no connection with the first matter. Because admittedly, first one is for not getting the upgradations. Other matters, they have admittedly got all the upgradations. So how can it be similar? I'm asking myself. But I can argue this first matter again, Your Lordship, because by now what must have happened is all of us need to refresh our memories. Because there is a lot of facts and figures involved.
That has to be. But I have one difficulty. What is happening in this case? My lord is noticing. Not only this, other matters were taken up. Heard. Conclusion of the hearing. She will make a prayer, my lord. I want to amend. It's not going anywhere, my lord. For last 1.5 years, my lord, these matters are being heard. Other matters were also heard. The end of the, my lord, conclusion of the submission, she will come up with a prayer, my lord. I want to amend the writ petitions. So I am saying, my lord, this is my suggestion, Lord, she will take up this matter.
Yes, I think even Ms. Paul is agreeable to that.
Not go anywhere, my lord. And Lord, she
Paul
has seen
It
the
was
number
taken
of
up. It was
adjournments.
reserved
Number
for
of
judgment.
adjournments. How many
Mr. Sen should have allowed
Let us
necessary judgment of this matter.
let us settle this once and just let us settle this once,
Yes, Your Lord.
once and for all.
We need to settle this for once and for all because we cannot continue arguing the same matter for 2 years together.
It's like
It's 2 years running now.
What Mr. Sen said is, it's embarrassing for everyone, for you as well as for me.
Lordship.
It's very unusual, my lord. It's never happened. 1.5 years, lordship. All the matters were virtually argued, your lordship.
Fine. What we will do is this: you refresh the court on as far as this matter is concerned. After that,
your lordship will see
simultaneously, or subsequently, we'll take up all the other matters.
And my lord, one thing I just pointed
So,
out.
Lordship, this matter, the first matter, number 4, may kindly be taken up.
Just a moment, please.
So far, this case is concerned, my lord, I think we have filed, so far Nehu is concerned, I think on 2 occasions we have filed, my lord, written submission.
You don't need to file.
No, my lord, written submission. But then I found it out, my lord, subsequently, my lord, it's too long written submission. So what I have already prepared, my lord, I have shortened it to 5-6 pages, small one. So next, when we will refresh, my lords, I'll just file that.
I think that will be. In fact, you have also filed your written submission, I believe.
We have filed our written submissions long back.
So you can just go through that and.
That one, virtually, from there, I'll just read out, I'll conclude, my lord. And thereafter,
So
lordship will see.
my humble submission, your lordship. So this argument that all has to be heard together, I think for once, I think we have to be very clear that item number 4 will be heard first and decided, and serially the next matter will be taken up.
Exactly, that is what the court intends to.
So I hope Mr. Sen does not retract on that. So for this, may I pray your lordship let this matter be taken up on Tuesday.
What is happening in this case? My lord is away. Adjournments after adjournments after adjournments.
It was reserved for judgment. That's my learned friend has gotten.
So we'll start.
Lordship, may I pray, Lordship, this first matter be taken up on Tuesday for fresh hearing. Item number 4, Surajit Datta.
Tuesday, in what case now?
Tuesday, 11.
We'll take it up on Tuesday, we'll take it up on 19th. 13, 14 will not be possible. Because 13 we have the full bench matter, so I don't think.
19, my lord.
Either 18 or 19.
This is your lordship. In a Friday, I don't.
Not 18 is not a Friday.
18 is.
18th is it?
Yeah.
Tuesday.
Yes.
18th would be the Tuesday after that. Yes, your lordship. But lordship will kindly indicate that item number 4 is going to be heard.
All the items will be. All the cases will be listed in the same serial, order as they appear, and we'll take up one at a time.
Lordship, if it is not indicated again, there will be confusion.
No confusion. I don't see why is there.
Lordship, because the other matters are part heard.
Whatever the case may be, we'll dispose of this, and then we'll, like you said,
So my humble submission, Lordship, kindly indicate that on 19th item number 4 is going to be heard and decided.
I have no problem. No problem.
Right.
Obliged.
Upon hearing the letter counsel for the parties, this matter, item 4, this matter will now be heard on 18th. Five, six, seven, eight. 5, 6, 7, 8. No? This matter, upon hearing the letter counsel for the parties, this matter will be heard on the completion of hearing of WPC 44 of 2015. So,
deeply obliged, Lord.
Yes, sir. Cut and die. Bone.
Item number 10.
Okay. Thank you.
Actually, this matter is pending filing up for written argument. Not. I pray for some more time. Not. 2 weeks time. Not.
Beginning like cut.
2 weeks time. Not. For written filing.
On pre-made by the state respondent, this is matter to 2 weeks.
Item number 12.
Item number 12, Lordship.
I'm prepared, Your Lordship.
You're for? You're a petitioner?
I'm for the respondent, Your Lordship.
Yes.
Please, Lord.
Your Lordship, I'm from respondent number 5.
Oh, you're a respondent?
5, yes. I'd like to bring before this Honorable Court, Your Lordship, as per the order passed by this Honorable Court on 5th June 2023. It has been brought on record, the government notification dated 1st April 2015, Your Lordship. In fact, the advance copy also as per the order.
Just a moment. You're referring to
that was
order dated?
As per the order passed by this Honorable Court. Yes. 26, Your Lordship. Or 5th, 6th. As per the order passed by this Honorable Court.
Yes.
5th, 6th, 2023, Your Lord. Even advance copy also has been given to all the parties concerned, Your Lordship.
Yes, so have you filed?
And the subsequent date, but due to the petitioner's absence, Your Lordship, it's been fixed today, Lord. I'm not feeling very well, but just now the throat, sore throat is having problem. Let's see.
Anyway,
I'm ready for the hearing. My senior is
have so you have no objection, or I mean, since notification is being filed, so there's no requirement to file a rejoinder.
No, Your Lordship. It's not necessary to file.
So we'll hear the matter on the next date.
Yes. Highly obliged.
Mr. S. Walang, learned counsel for the respondent number 5, has submitted that in compliance with this court's order dated 5/6/2023,
yes,
the relevant notification has been brought by way of an affidavit before this court. The petitioner, as well as the other respondents, has no objection to the same and has made a submission that this matter may be finally heard. On premier, list this matter for hearing after 2 weeks.
I think.